can talk about what's going on briefly, and if anybody has questions, we'll certainly entertain those questions. Let's start with what was so exciting last year, which was everybody recall FIDE and us and 4 other large Western federations, along with Karpov and Kasparov. We're going in to try to do something about FIDE elections and the Legal.wmv ticket. That was all rather unsuccessful, as I think most of you know by this point. White & Case, one of the most reputable firms in the country, represented us pro bono. They continue to represent us pro bono. Bottom line is we lost that action in the Court of Sports. They essentially declared that this was all inside baseball. That, you know, you're a big, happy family chess. Go work these things out for yourself. We really don't want anything to do with it. They tagged the plaintiffs, or the petitioners, as they're called in this particular action, with some modest amount of fees. My recollection is that Kasparov and Karpov paid all of that. FIDE then went back in because CAS left them with about €1 million shortfall on their legal expenses. FIDE went back to the federal court in Switzerland and asked for an appeal. The federal court won't touch the substantive matters that were before CAS, but they would say that procedurally they did not think that CAS gave FIDE its day in court, its opportunity to be heard. So it sent the action of whether or not the petitioner should have to pay more of FIDE's legal expenses back to CAS, and it has been there for ages. Ruth, I mean, we're talking 7, 8 months? How long has it been there?
And it's not scheduled for hearing.
Yeah. Our counsel at White & Case tell us that no one is going to be very excited at CAS about rehearing this. They've made a decision. They've said, here's what has to be paid. Those monies have been paid. FIDE is going to say, you know, please reconsider. We're not expecting anything momentous to come out of any decisions in CAS. Is there the potential there? Is it possible? Yes, it is. It's possible that as a legal matter, those 5 federations would be held jointly liable for any additional fees, legal fees to be paid to FIDE. We still anticipate and fully expect that Karpov will make good if any of that money has to be paid. There's been some discussion today, and I'm just being real candid and forthright, that we should go back in and check with Karpov 2010. There's some doubt in some minds that Karpov 2010 is still a viable organization. The website, I'm told, has been brought down. I have not checked it today. Savan is nodding his head to affirm that it has been brought down. I do not believe that means that Karpov 2010 is a defunct organization. I also do not believe that means that Karpov would not honor any judgment that might be rendered against the USCF. Sir?
Karpov 2010 still shows up as being a non-dissolved corporation in New York, so they haven't dissolved the corporation.
I can't imagine that they would have dissolved it. I don't think Karpov is done. There may not be much left in this round of FIDE elections, as you know, which are well behind us now. He's still out there as a viable candidate in the future, and that's really not part of this forum. We can talk about Jenna versus Karpov in the next hour, which is the international seminar, if anybody wants to get further into that. So that's where the CAS action of last year sits, waiting patiently. We've been waiting for months and months now for anything else to come of this. White & Case is very confident. I don't know what to tell you to make of that, because White & Case also told me they were pretty confident in the last action. So we'll see. They say that their Swiss counsel that are representing us in this action have heard on the streets that CAS is rather upset today because they've gone back in to ask for these fees. But that's scuttlebutt, and I don't know how reliable that information is. So before I move to the next subject, does anybody have any questions about the CAS arbitration in which we were a party and a plaintiff last year? Okay, good. these things do get posted in the issues form. If you ever care to go there, I will be the first to concede you have to read past a whole lot of noise to get to stuff that matters, but there is stuff that matters there. And I'll also concede that I'm probably a contributor to some of the noise now and then. So do look in every once in a while. We put stuff up about these litigation matters there all the time. The next issue, and I may ask Ruth to help me with this one because I haven't been nearly as involved with it, is Karpov and Kasparov along in the background with two federations taking the foreground. Is that true?
I think it's the UK and Georgia, and it's regarding the appointment of extra vice presidents. And it's my understanding that that is also going to pass arbitration in mid-October. And that's all I really know. That was the latest update on that.
At the end of the FIDE elections this last time, and Savan, you were there, please feel free to chime in on any of this. There was a little bit of a furor about the fact that there were some additional, how many? 5, 6?
There were 5 vice presidents appointed, and
I think there were 4 extra ones that were put up.
yes.
All right. Anyway, somewhere between 4 and 6, there were appointments made of additional vice presidents beyond those called for in what I'll describe as the bylaws of FIDE. Those were seen as sort of, many saw those disparagingly as quid pro quo kinds of appointments. I think that that's a fair reading of the situation. I'm sure that there are others who dispute that's what was going on, but we have now Kasparov and Karpov behind 2 Western federations going back into CAS to challenge those vice presidential appointments. I can't really tell you how that's going to interact dynamically with our appeal that's in front of the same court involving FIDE at the same time. I don't know how that will all play out, but that's what's going on. I know Beatrice is here now. Beatrice, also feel free to speak to any of these issues. We're now talking briefly about the action that has been brought in CAS respecting the additional FIDE vice presidents. So are there any questions on that second arbitration in CAS right now?
Just for me to be clear, are you definitively saying that USCF is not involved and has nothing to do with that action?
All right. And now, you're triggering the lawyer in the, definitively nothing to do. I will tell you that as an executive board member, and from my understanding of things, we have nothing to do with the action in CAS involving the FIDE vice presidents. If anybody has information differently, it'll be news to me, and please speak up. My memory is, again, being forthright and candid, correct me if I'm wrong, my memory is we were asked to participate in this at some level. Is that true, Ruth?
That's true, and we declined.
And we declined. This was months ago. This was months ago. There were folks fishing about for petitioners in that action, and we did not find them.
We signed a protest letter initially when the initial appointments happened, but when they decided to go to CAS for arbitration, we decided that a protest letter was appropriate, but going back to CAS wasn't.
Was the decision to decline joining that action based on an executive board motion and vote?
Not to my knowledge. I don't recall a motion or a vote. I do recall a discussion.
So there is
No one moved. No
You
one
can't have a
moved.
motion to do a negative.
Yeah. I mean, don't expect.
But there
I
could have
agree
been.
with that, Gerald. There's not necessarily going to be a motion, but a lot of times there's going to be a discussion, and then the motion would be for the affirmative. But the affirmative in this case would be to join in, whatever we're going to do. And my recollection is, I am just remembering, back months ago, is that we've never had enough energy to get a motion off the ground to go into this. And you know what? I'm not even talking about the merits of the issue. I may personally, as I sit here today, think that it had a lot of merit, but we were also a little bit gun shy, as you might expect at that particular moment in time. We had just rolled out of Irvine and a large tussle over, with some folks who didn't necessarily agree with the way we did the last arbitration, and frankly, we had that additional hurdle to overcome this time before we went running back in again.
Can you assure me, please, that the discussion resulting in the decision to decline joining the action was among all executive board members?
Yes, I can assure you that. Now, so let me also caveat and say that there were probably some sidebars that were occurring in 2s and 3s, but there was a general discussion among all members at some point in time when the decision was made. Mike?
I remember there was some kind of, which was 6-4 and I abstained. And I thought that was to get into to join the other countries.
Well, we can go back and look. I don't recall a vote on joining the arbitration. There may have been a vote somewhere along the lines of the letter
That was the letter.
that was
Might
sent.
have been the letter, because I think by the time we had that vote in Crossville, the deadline had passed to actually join it. It was too late to join.
We were wearing lead shoes.
We weren't part of the initial letter. We were too late.
Yeah.
Yes, I listened to the study of the meeting. Concerning the case, the first case, that FIDE versus the USCF and other federations for cost for the, I believe that the case is in class, obviously, and they're waiting to appoint the panel for the hearing. But it's only for cost. Since Karpov Inc. agreed to assume any costs related to litigations, the USCF should not have any exposure there. And by the way, somebody said that the presidential board took a vote to sue the USCF and the other federations. That was never the case.
Yeah, and
It was not even mentioned to the presidential board.
That's
It was
fair.
a decision made by the treasurer and the president.
And let me just say, because it's my nature in these things, is that I believe that notion came from me in a phone call with you at some point. And I want to say that I could well be mistaken about that. It was my understanding that there was a presidential vote at FIDE level to sue, and
No, it
that
was
may
not
be mistaken.
represented, no.
Right.
It came directly from the office to the treasurer. It's a finance, he's from England, Nigel Freeman, and he thought that financially, since FIDE spent €1 million, money that will be spent in chess, defending this case against Karpov Inc., they would like to go for the cost. I believe that the court already ruled that some expenses will be paid to them, but now they want to pay more. So I don't know exactly. Right now just sitting there.
Well, I can appreciate that it's money that would be spent for chess, but I'm not sure that they're going to get to $1 million from a place where it wouldn't have been spent for chess. Okay, so no election at FIDE to sue the USCF and other federations. Have I given you all the assurances that you're looking forward to?
Thank you, yes.
Despite the caveats.
Do these new vice presidential positions have an actual function, and are they paid positions? Or do you know?
I really don't know. I don't want to put Beatrice on the spot, but I don't know the answer to that question. Did you hear the question? The question, Beatrice, was do these new FIDE vice presidents have actual positions within the federation, and are they compensated for their services?
No, nobody gets compensated. All FIDE officers, they get expenses paid to the meetings. Some of them, they have their own budgets. When they're presidential, continental presidents, then they manage their own budgets. But overall, people don't get, there's no salary for anybody in a committee or any position in the board. Similar to the USCF.
I can assure everyone that
Hmm?
no one gets Well, except Bill. All right. For those that are just joining us, we have discussed briefly the CAS arbitration that was front and center last year. This time, we have then kind of spun off and discussed a little bit the second CAS action, which the USCF is not a party to, involving the additional vice presidential appointments at FIDE. And I think we're done with those unless anyone else has any questions concerning either of those two actions. All right. I've only got one left. Is there more than one left? All right, the last one is Sam, where are you? Sam's never here.
He's in court getting that TRO.
Yeah, okay. Well, I guess that's the latest breaking on this issue, is that Savan tells me that there's a forum posting in the last, I don't know, a couple hours perhaps, in which Sam has gone back into Illinois court to try to get an injunction, and the injunction would be to enjoin the USCF from seating its new executive board members. Alan, are you here? This one's pointed directly to you, buddy. Well, I guess that would be me too, though, wouldn't it? Yeah. All right. Well, okay.
I think it was
So-
a temporary reprieve.
Yeah. So we'll see. We'll see if the court gives him what he wants. Remember, this was all filed back in April. Well, he served us in April. He probably filed it in March. The court hasn't done anything. It didn't do anything to slow down our elections.
He did receive an ex parte hearing at one point and got a negative response, tried to get another ex parte hearing, never was able to achieve that, and then didn't act for many months. So if it's, to get a temporary restraining order like that, you're going to have to show that you put forth significant effort in trying to see it through all the time, and he's not going to be able to do that.
Yeah. Look, God bless Sam. There's, I think he's doing what he thinks he ought to be doing. For those of us who work, play lawyers in real life, sometimes we recognize his pleadings as being rather incompetent. And to a judge, it's hard for me to describe how a judge would receive the pleadings that are put in by Sam. But the truth is, I think most of you could probably guess if you've read the pleadings. They're just not going to be well received. And that's not to say, though, that he won't occasionally find, or any plaintiff won't occasionally find a judge that is very anxious to make sure that every person gets their day in court. I don't know if he has such a judge in this case or not. I sort of doubt it. Judges are like most of us. They get jaded after a few decades of doing this stuff. And when something like that rolls in front of them, they give it the back of their hand. So we'll see. This judge has not responded to Sam to date, and I guess Sam's going to make one more try before Sunday. Today's Thursday, right? So I doubt the judge is going to come in on Saturday morning to deal with this issue. So unless Sam is successful tomorrow, Alan's just going to have to take a seat.
One sad aspect of this, and if it was not for this component, it would be a very laughable situation. But as of the end of the fiscal year, and this is not the final tally at this point, but as of the fiscal year, we'd spent $17,000 on this. At some point you have to scratch your head and say, this is the third lawsuit. At what point does a member be too expensive to retain as a member? So maybe that's something that the delegates ought to think about.
Well, do think about that. I mean, and if you want to, let's discuss very briefly the merits, if there are any, of Sam's lawsuit. And Sam, the crux of Sam's lawsuit is that we did not lay out for him adequately a list of the delegates such that he could go out and notify all those delegates and find his 15 delegate signatures in 5 different states. And as you all know, both bylaws and the GTF have been working very hard at trying to figure out the right way to come at this issue. We've got an issue where there are a lot of delegates / directors running this corporation, and very difficult for us to know who is seated and who is not seated at all times. Now, there are periods of time where things settle down and we can come up with a comprehensive and definitive list. But there are other times, especially as you get toward the end of the calendar year, in which it's very difficult for us to say with absolute clarity who are all the delegates who are presently seated. We think that we've got some things coming down the road in the next few days that are going to help us clean that up so that we can point to both our delegates and our directors and say, here's who they are, here's who you contact, here's who you need signatures on your petitions from. So that's, that's at the crux of his complaint, but I will say this too, that I have now had reviewed for me all the letters, all the information that was provided to Sam during the process leading up to the deadline for submitting the petitions. And I will tell you that no one in the history of the USCF has ever been more mollycoddled than Sam was in getting these names and addresses delivered to him so that he could go out and get his signatures. And I don't mean to pick on Sam, I really don't. But I have to tell you, I'm very irritated by this one because Sam was in the room with us all. Most of the people in this room right now were in the room last year when the petitions were being passed around, and they could have easily have been passed around for Sam. And a lot of us would have signed for Sam because a lot of us feel that, look, you've got a right to get on the ballot. Now, I don't particularly agree with that. But I would suggest to you, and we can talk about this if you want, I would suggest that the right way to come at the petitions is, if you feel that a candidate is qualified to serve in the office, sign the petition. Just ask yourself, are they qualified? Whatever the minimum qualifications are that you've come up with for yourself, ask yourself, is this person qualified? Then by all means sign their petition. And then when it comes around to your vote, simply ask yourself, who is best qualified? Who's qualified, petition? Who's best qualified, vote? I think that's an intelligent way, and I think that's the way that the petition process should work. And having said all that, that we have members that none of us as delegates should be signing petitions for, and I'm not mentioning any names whatsoever. All right, I think that's, I'm sorry, legal used to be such an exciting workshop. This year, a little less so. Savant.
Is the insurance company covering us? Because why is there a $17,000 bill for them?
We still haven't gotten the final opinion letter from the insurance carrier. We've had the attorney requesting that, and they had an initial partial denial, but they're continuing to renew. So you have to pay as you go along.
Isn't the deductible almost
The deductible's $10,000. So we're going to absorb 10 of that 17.
But on some of the previous actions where we had to have coverage, a lot of times we had to pay and then get reimbursed from insurance as well. So.
It's a typical fight. They don't roll over easily and say you're covered. Our counsel are experienced in going after them, saying, no, this, even if those claims aren't this claim, usually if you can get one or two of the claims in underneath the policy, you will be able to ride your fees through. You just got to get one of the claims in. So we'll keep pursuing that. Counsel is doing that for us right now. And
Actually, kind of an example of that, funny enough, the only reason that we had insurance coverage on Sam's second lawsuit against the Federation was because he claimed financial misdoings by, I think, probably me, he had some claims in there of financial misdeeds by board members, and that triggered a clause where we actually got coverage there in the second lawsuit. So sometimes it's very bizarre things that trigger some sort of coverage.
right. Well, unless there's something else, happy to answer questions. Happy to discuss anything that's on the legal landscape that's not involving a lawsuit.
Have we thought about potentially just adding in a clause to the membership of saying, they have to go through arbitration instead of filing an actual lawsuit? Would that even hold? Would that even hold? Would it be?
I don't have a lot of confidence in our arbitration process. But
first that's ever been raised to me. I'm not, is anyone aware of a membership organization that requires a consent to arbitration for membership? I'm not aware of it. It's,
Would you join such an organization?
I don't know. I hear you, Guy. It's,
I mean, I don't know if it would even, help us from a cost perspective if, like in this scenario or other scenarios, but something to be able to protect us from that serial litigant.
right. Yeah, I can tell you that the single most expensive case that I've ever been involved in from a legal fees perspective, and this is as a lawyer, not a party, was an arbitration.
Okay.
So sometimes it's cheaper, sometimes it's not. Anything else on the legal front? All right. Happy to stick around and answer any questions anybody might have. Are we back in here again for international next hour?
Wait a minute, do we cover the legality of our ADMs and our direction of delegates? As who's the board of directors? Illinois nonprofit?
No, we have not talked about that.
There may be some aspects of that that, I mean, most of that is bylaws. I think.
Well, I'm hoping that we're going to reach this issue, if we reach it in bylaws at GTF tomorrow. Darrell, is that true?
Yeah.
Yeah.
So that's more appropriate than legal?
Well,
If there's specific questions on those things, try. We don't have a lawsuit about it. Historically, that's what the legal meetings are.
plus now I've got an extra 12 hours to think about it.